Are early termination fees in residential tenancies in California enforceable? Hi, my name is Rob Wells. I'm the landlord warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I've been getting this question quite a lot lately, especially from property managers. The scenario is this: they have some type of pre-negotiated early termination fee in the lease agreement. It's usually 1 or 2 times the amount of rent. And the question always is, Rob, are these legally enforceable in the lease agreement? And then some of the other ancillary questions are, can you take them from the security deposit and so forth? Well, let's start off with this. In California, early termination fee in a residential lease agreement is in legalese a liquidated damage provision. Okay. The Civil Code governs liquidated damage provisions, okay, and that's at Civil Code Section 1671, okay, and there are two types, okay. So for consumer contracts such as residential tenancies, the rules are governed under Civil Code Section 1671, Subdivision D. Now, the easiest way for me to explain this is the Civil Code section for residential or consumer contracts. It presumes that liquidated damage provisions are presumed void, except for the fact that when a landlord can establish that from the nature of the case, it would be impractical or extremely difficult to fix the actual damage. Okay. And then there's a bunch of bodies of law actually that go into this, at least in residential tenancies. I think the cases really relate to late fees, where damages, landlords couldn't prove that their damages were extremely impractical or extremely difficult to fix, and they voided out late fee provisions because of that. Now, in our scenario here, the damage provision would only apply if the tenant breached the contract early. Okay, let's say it's a year lease, right? You're 2 months into the lease and you got 10 months left, and the tenant goes, hey, listen, I'm boogieing, landlord, see you later. You figure it out. Here's your property back. Okay, that's obviously a breach of the lease, right? Because you signed a year deal. Okay, now here's my take. Okay, this is where attorneys differ. I don't think an early termination fee is going to be enforceable in a residential contract on a lease break. The reason why is your damages can be readily ascertainable. Okay, and normally how you have to do this is, okay, you got 10 months on the lease, right? The general principles of law and contracts here is in the Civil Code. It's actually in, I think, Civil Code Section 1951.2. Those are the damages for breach of lease. Okay, long story short is landlord, is gonna know what the breach of lease is, because you know the term. Okay, you know how much the rent is because you have a lease agreement that spells out what the rent is. Okay, and a landlord generally has a duty to mitigate their damages, and that's actually built in the Civil Code. So what are some of the reasonable costs that a landlord can get compensated for? Okay, well, you're gonna have to probably remarket the property. If you're using the property manager, you probably might have to pay them a commission. You're gonna have incidental expenses for like screening applications, that type of deal. So those things could be awarded to you. And then if a landlord has a certain criteria, for example, let's say, you have to make, 3 times the rent, and, you have to have a sufficient credit score, it might take a little bit of time to actually find a tenant that was as qualified as the one breaching the lease or better. Okay. And if the landlord, it takes them 2 months to find that qualified person, so to speak, well, we know that's, I got 2 months of lost rent, on the 6-month term. And then let's make it simple. Okay, let's say you're renting the place for $2,000, and the tenant breached that lease agreement, but then market conditions go bad, and now they can only rent to a qualified tenant for $1,000. Okay, type deal. Well, the law or the court can, or if you file a breach of lease suit, you can be compensated the difference on what the tenant was supposed to pay versus, the actual what I received, basically. Okay, I had to mitigate my damages. I had to find someone qualified, but I had to take a loss on the rent. So the tenant that breach the lease could be on the hook for the difference. Okay. Those are ascertainable. Okay. I don't think that's very hard to find out. And I don't think you're going to have a really great time trying to convince a judge otherwise here. Because the questions I was getting is, well, can't I just, take the liquidated damage fee and sue for damages? Well, no, it's a double recovery. And I don't think under Civil Code Section 1671, you're going to get any love in court. So I think because of the way the law is written, it's presumed void. You got to put on evidence that is not ascertainable and reasonably calculated. And just from what I discussed here, I just think you're going to have a hard time here. So those are my thoughts. Landlords, if you have a problematic tenant situation, like, the tenant's not paying rent, they're keeping up possession, you need to possibly do an eviction, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, talk to you then. See ya.